It was 9:14 on a Tuesday morning when a black Cadillac SUV came up my road and parked half on my flower bed. I was on the porch of cabin 3, kneeling, fitting a fresh cedar baluster into the railing before the weekend renters arrived. I heard the tires on the gravel before I saw the vehicle. People who belonged here slowed down at the sign that read, "Private cabin guests only." This one didn't. The driver's door opened, and Diane Haverson stepped out in a navy blazer and pearls holding a clipboard, the way some people hold a badge. Behind her came Greg, the HOA's so-called compliance officer, already lifting his phone to photograph my front porch. They had picked without checking the one homeowner on this lake, whose father had taught him that paperwork is the only thing that ever really holds. I stood up slowly, hammer still in my hand. "Sir," Diane said before I'd even spoken, "step away from that railing. As of last week's vote, this property falls under Lakeside Pines' HOA jurisdiction." She pushed an orange-edge notice into my chest. Greg circled cabin 3 with a measuring tape, calling dimensions out loud, like he was inventorying a foreclosure. He photographed my father. Front door. He photographed the lake behind it. Then he peeled the backing off a yellow sticker that read "Code Violation Pending Compliance" and slapped it onto the porch post 6 inches from my elbow. I didn't move. Behind them on my own road, the engine of the Cadillac was still running. I remember thinking very clearly that she'd driven up that road every morning for 12 years. I wondered if she'd ever once looked at whose name was on it. Maria's hatchback came up the drive next. She was my cleaner, 61 years old. 2 kids in college, the most reliable person I'd ever hired. She got out with her bucket and a stack of folded sheets and froze when she saw the sticker on the post. Diane pivoted toward her without lowering her voice. "Ma'am, you can leave. Every cabin on this property is now subject to HOA, architectural review, and short-term rental compliance. Mr. Reyes owes the community $87,000 in back dues calculated since the 2014 amendment. Until that's paid, and a transfer of management is signed, no operations are authorized." Maria looked at me. Her hands were shaking around the handle of the bucket. "If you're not signed by Friday," Diane went on, "half to me, half to the porch boards. The board files a lien on every structure, 15 cabins, everyone, and will pursue full transfer of title." There was a kind of pleasure in the way she said 15, like a number she'd practiced. I unfolded the orange notice and read it slowly. The way my father used to read documents top down, line by line. The way a man reads the small print on something somebody else needs him to sign. It was 3 pages. It cited covenant amendments. It cited board minutes. It cited a community standards review. What it did not cite was a recorded easement, a deed reference, a county plat number, or a single line of property law I'd recognized from the file box under my desk. It was paper dressed up to look like power. I folded it back into thirds. "Friday," I said. "I'll have an answer by Friday." Diane mistook the sentence for surrender. I saw it land in her face, that small tightening at the corners of the mouth that confident people make when they think they've won early. She nodded once sharply, and turned back to the SUV. Greg took 2 more photos for the road, slid into the passenger seat, and they backed down my drive in a long, graceful arc that took out the corner of my hostas. Maria waited until the sound of the engine was gone before she set the bucket down. "Mr. Reyes," she said quietly, "can they really do that? Take the cabins?" I looked at the yellow sticker on the porch post. I looked at the fresh tire tracks across my flower bed. I looked at the half-mile of black asphalt road my father had laid by hand in 1978, running straight back through the trees toward 96 houses that had no other way home. "They can try," I said. I walked Maria back to her car and told her to take the day, paid. Then I came back up the porch and stood for a long time with the orange notice in one hand and the hammer still in the other. 12 years. Diane had been driving up that road for 12 years. The board had been making decisions about my property for at least 3, and in all of that time, not one of them had walked into the county recorder's office and asked the only question that mattered. I peeled the code violation sticker halfway off the post and then stopped, left it hanging there. I'd want it later for the photograph and for the file. Then I went inside, sat down at my desk, and looked at the small fireproof metal box on the floor beside my chair. I hadn't opened it in 8 years. I hadn't needed to. My father had told me once that the land is what they take, and the paperwork is what holds them off. And I'd kept everything he gave me locked up exactly the way he'd handed it to me at his kitchen table in 1998. I rested my hand on the lid. They just didn't know yet which one of us actually owned the way home. The metal box sat on my desk for the rest of that morning before I opened it. I made coffee first. I always do that when I need to slow down. I poured a mug, walked back to the office, sat in my father's old leather chair, and looked at the box the way you look at something you've inherited, but never used. It was 16 and wide, fireproof, painted a flat industrial gray. On the lid in my father's handwriting was a small white label that read Ray's Land. He'd handed it to me at his kitchen table in 1998, 3 months before he died. The land is what they take, Carlos. He'd said the paperwork is what holds them off. I'd said yes because at 26, you say yes to your father. I understood it now. My father, Manuel Reyes, bought 40 acres of lakefront in 1978 from a tobacco farmer's widow who needed to sell fast. He was the only Mexican landowner on this lake at the time, and he knew the way men of his generation knew that anything he didn't have on paper would not be his for long. So, he papered everything. He recorded the deed the same week he signed it. He hired a surveyor to draw a recorded plat. He filed both under a holding company he'd set up the year before, Riaz Holdings LLC, and kept the receipts in a manila envelope I was now 48 years later looking at. Then, he started building. He built the first cabin himself in the summer of 1979. By 1998, there were 15. He paved every road on the property himself, including the half-mile of asphalt that ran back toward the woods. The county had refused to extend public infrastructure that far, so he hired a contractor and did it out of pocket. That road, the one Diane had driven up that morning, had been laid by my father with money he'd earned painting houses. Lakeside Pines came in 1995. A developer named Patrick Holloway carved 96 lots out of the woodland on the other side of my father's road. To reach those lots, every truck and resident and FedEx van had to drive over it. There was no other way in. Holloway came to my father's kitchen in 1995 and asked very politely for a recorded easement. My father said no. What he gave Holloway instead was a revocable license. It was drafted by a county attorney named Eleanor Pace, who that Saturday afternoon at our cabin sat at our picnic table and explained the difference to 19-year-old me in 2 sentences. An easement runs with the land forever, son. A license is permission you can take back. She looked at my father. You sure that's what you want? He nodded once. Good, she said, because someday they will forget. I sat in his chair 28 years later and remembered her saying it. For 30 years, it didn't matter. Holloway sold his lots and moved to Florida. Families moved in. They drove the road, waved at my father, came up to buy firewood. The first HOA president was a retiree named Walter Briggs, who once sent flowers when my mother died. Diane Haverson moved into Lakeside Pines in 2014. By 2019, she was on the board. By 2022, she was president. Somewhere in those 8 years, she did the thing that ambitious board people do when they get a little authority and no real check on it. She started reading the bylaws as if they were scripture. The amendments started in 2022. Architectural review, short-term rental restrictions, fines. For grass length, fines for the wrong shade of mailbox. The pattern had been building for 2 years before it ever reached me. What reached me first was the math. Last summer, I cleared $214,000 net on the cabins, 15 units, weekend rentals, June through September. The numbers were public if you knew how to look. Diane did. The first letters came in March. Voluntary registration. April, compliance review. May, a business card. June, the orange notice on the porch. Each one had used a slightly bigger word for take. I opened the box. The 1978 deed sat on top in my father's handwriting. Recorded the 14th of June, 2078, Ray's Holdings LLC, lakefront parcel, 40 acres. Beneath it, the surveyor's plat. Beneath that, 3 folders of tax receipts, insurance, building permits, and at the bottom, in a manila folder by itself, was a single document, 12 pages typed on a 1978 Select Electric, with a blue notary stamp on the last page that had faded almost to lavender. The header read, Revocable License for Ingress and Egress, Lakeside Pine Subdivision. I didn't read it yet. I knew what was in it. Eleanor Pace had explained it to me with a plastic fork in 1995, and my father had written my name in the margin of page 7 the day he handed the box over. I picked up the phone instead and called my brother. Rayon was a paralegal in another state, 3 years younger, careful in a way I never quite was. He picked up on the second ring. "Carlos, everything okay? How do you legally revoke a license to use a private road?" There was a pause, then he laughed. "Carlos, what did they do this time?" I told him. He stopped laughing about a third of the way through. When I finished, he was quiet for a long moment. "Get the original document," he said. "Read it clause by clause. Don't do anything yet. Don't send anything yet. I want to see it. And Carlos, don't tip her off. The bigger she swings, the harder she falls. Just don't say anything Friday. That gives her a reason to call her own lawyer." I told him I wouldn't. I hung up and sat in my father's chair with the manila folder in my lap and the afternoon light coming sideways across the desk. The road outside the window was empty now. The yellow sticker was still half peeled on the porch post of cabin 3 where I had left it. I could see it from the desk if I leaned forward an inch. I leaned forward an inch. I left it there. I spent Wednesday, 9th Thursday, photographing every page of the license and emailing the pages to Rayon. He called me back Wednesday night. "Read Clause B to me," he said. I read it. He was quiet for about 10 seconds. "Don't say a word about this on Friday, not one word. Let her commit." I told him I'd already planned on it. By Friday evening, I was sitting in a folding chair near the back of the Lakeside Pines clubhouse with 30 other people, my phone in my shirt pocket, the audio recorder running, the screen dark. I had checked the law twice. This is a one-party consent state. A man can record a conversation he is part of and use it. I was invited. The phone was on. Diane stood behind a podium in a charcoal blazer with her clipboard open in front of her like a missile. 2 other board members flanked her at a small table. Greg from Tuesday and a thin woman named Lorraine I'd never spoken to in 12 years. I sat with my hands on my knees and watched the room fill. Hank came in last. Jaman and Half, 78 years old, retired surveyor, lived 3 doors down from the clubhouse since 1991. He saw me, lifted his chin half an inch, and took a chair against the back wall. He did not sit near me. He did not need to. Dia Nee called the meeting to order at 72. She read the amended covenant of 2014 aloud. Slowly, with the particular emphasis some people put on language they wish they'd written themselves. The phrase that mattered came 40 seconds in. "All contiguous lakefront parcels accessed via community infrastructure shall fall under the jurisdiction of the Lakeside Pines Homeowners Association." She let it hang. Greg stood up and walked around the table to where I was sitting. He held a manila folder. He set it on my knee formally like a man serving papers. "Mr. Reyes, the board has prepared a notice of pending lien. The amount is $87,416, payable in full, or by structured settlement no later than Sunday, at midnight." I opened the folder. The number was printed in bold near the top of the page. $87,426. I did not say anything. I did not need to. The room was watching. I closed the folder and set it on the empty chair beside me. "Miss Haverson," I said, "may I ask 3 questions for the record?" Diane looked up from the podium, surprised, I think, that I'd spoken. "You may." "First, does the board claim jurisdiction over my 15 cabins under the 2014 amendment?" "Yes." "Second, does the board base its access to this clubhouse and to all 96 homes in this subdivision on the road that runs past my property, the community road?" "Yes." She used the word community. I did not correct her. I let it sit. "Third, has the board ever reviewed the recorded easement or license for that road?" She made a small impatient gesture with her hand. "We don't need to. It's been used by residents for 30 years. That's settled." I sat down. I did not argue. I did not respond. I closed my mouth and folded my hands and let her have the silence she thought she'd just won. Diane read it as defeat. I watched her shoulders shift back a quarter inch under the blazer. She glanced at Elrain and gave a small nod, the kind that says, "We've got him." She turned back to the room. "The board files the lien Monday morning," she announced. "Mr. Reyes, you have until Sunday at midnight to deliver signed compliance and a check, or every cabin on your property will be encumbered. We will not be holding this offer open further." A few residents shifted. A woman in the second row, gay-haired, kind face, looked at me with something I read as worry, not approval. Hank in the back slowly shook his head at her, not at me. The meeting adjourned at 7:31. I stood up, picked up the manila folder, and walked out without speaking to anyone. The parking lot was full of the kind of light that comes off a clubhouse at dusk, unkind to faces. I was unlocking my truck when the woman from the second row caught up with me, half jogging in flats. "Mr. Reyes?" I stopped. "My name is Sarah Whitlow. My father did the survey on your land in 1978, Ed Whitlow. I don't know if you remember him." "I remember him." She nodded, took a breath, looked back over her shoulder at the clubhouse door. "Diane is doing this to other people too. The Coopers, they had a pontoon boat. She fined them $9,400 for the wrong color of tarp. Kept finding them every month until they sold the boat to pay it. The Patels refinanced their mortgage last year, refinanced for landscaping fines that didn't exist when they bought the house." I held her eyes. "She picked you because the cabins are big money. Sarah said she thinks you'll fold the way the others did." "I know." She studied my face for a moment. Whatever she saw there seemed to settle her. "Whatever you're going to do, Mr. Reyes, please don't roll over." "I'm not good." She paused. "My father liked yours. He said Manuel Reyes was the one. Only landowner on this lake who paid every invoice the day it came in." She walked back to her car without looking at me again. I drove home with the windows down. The road through lakeside pines went past darkened houses, past mailboxes, painted the regulation color, past a stop sign Diane had probably approved the placement of, and then over the line where the subdivision ended, and my father's pavement began. I felt the seam under my tires. That night, I felt it differently. I parked at the cabin, walked into the office, sat down at the desk, and opened the metal box. I took out the 1978 license, 12 pages, faded notary stamp, my father's signature, and fountain pen at the bottom of page 12. I laid it flat under the desk lamp. The phone in my shirt pocket was still warm. I pulled it out, opened the recording, and watched the waveform stretch across the screen. 46 minutes and 12 seconds of audio, including the 3 answers Diane had given me on the record voluntarily in front of 30 witnesses. I saved the file twice, once to the phone, once to the laptop, once more to a thumb drive I kept in the box. Then I read Clause B, by lamplight. Slowly, "This license shall terminate automatica. Ellie and without further notice upon any assertion by Lency, its successors, agents, or governing entity of adverse interest, jurisdiction, or claim of ownership over any portion of the licenser's adjoining lakefront parcels, or improvements thereon." I read it twice. Then I leaned back in my father's chair and looked at the ceiling for a long time. Diane wanted it on the record. Now it was on mine. Sarah called me Saturday morning at 7:30. "Mr. Reyes, there are people you should hear from. My kitchen, 10. I've already called them." I told her I'd be there. I brought the metal box. Sarah's house was a small ranch on Birch Lane, half a mile from the subdivision gate. She met me at the door with coffee already poured. There were 5 other people at her kitchen table. Hank, the retired surveyor, in a flannel shirt and reading glasses pushed up on his forehead. Bill and Linda Cooper, both small-framed, both with the look of people who had been embarrassed by something that wasn't their fault. Anali and Raj Patel, early 40s, well-dressed in a way that meant they were trying to look composed, and a younger man in a Carhartt jacket, mid-30s, laptop already open. Mike Delgado, IT contract. Or, "Mike has something you'll want to see," Sarah said. "But let everyone tell their own story first." I sat down. The Coopers went first. Linda did most of the talking. They had bought a 14-foot pontoon in 2021, stored it tarped in the side yard with HOA, written approval. In 2022, Diane fined them $400 for the tarp color. The next month, again, same tarp. They asked which color was acceptable. She did not answer in writing. She kept finding. By the end of 2022, the Coopers had paid $9,400 in fines on a tarp that violated nothing in the recorded covenants. They sold the boat in February of 2023 to a man in Tennessee for less than they'd paid for the trailer. Bill put a manila folder on the table. Every fine notice, every check stub, the original recorded covenant. No clause about tarp color. There never had been. I wrote Cooper's $9,400. No covenant basis on a yellow pad. Ainley Patel went next very quietly. They had bought their house in 2019. Standard landscaping. In late 2023, Diane began issuing fines for non-conforming plant species. A list of 7 shrubs the HOA had never previously identified, all of which were in the Patel's yard the day they closed. $14,000 in fines over 14 months. They had refinanced in February to pay them off and avoid a lien. I wrote Patel's $14,000 fabricated species list refinanced. Hunk was brief. She tried it on me in 2022. Fence height. I told her come back with a court order. She never did. Use my name. I wrote Hank Bauer willing witness. Sarah turned to Mike. Mike worked the HOA email server contract in 2023 and 2024. Show him. Mike turned the laptop toward me. 26 months of archived HOA emails plus a financial summary spreadsheet. I lost access in December when I asked the wrong question, he said. But I have everything through November. He clicked the spreadsheet. The line called Board Discretionary Fund. Every fine the Coopers paid, every fine the Patels paid, plus about 30 others. None of them flowed to community maintenance. They flowed here. And here's where it spent its money last year. $11,000 to a consulting firm called Haverson Strategy Group, registered to Daniel Haverson, Diane's brother-in-law, no website, 1 employee. The room went quiet. I looked at it for a long time. This was the kind of receipt that could end careers. It was also the kind of receipt that could swallow the entire story. Mike, I said, I want a copy on a thumb drive before I leave. I want you to sit on it until after Thursday. After Thursday, you and I walk this folder to the State Attorney General's office in person. It's not what wins my case. My case wins on the road. This is what ends her. He nodded. Sarah looked at me with the same expression she'd had in the parking lot Friday night, the look of someone confirming she'd bet on the right horse. I asked each of them to write a short signed statement. Half a page, dates, amounts, what Diane had said, and when. 5 pages in their own hands. I left Sarah's house at noon with the statements in the metal box and a thumb drive in my jacket pocket. I drove home and went straight to the desk. I did not call Rayon yet. I sat down with the 1978 license under the lamp and read all 12 pages, every clause in order. 3 clauses mattered. Clause A, $1 param per lot, payable in perpetuity until revoked. Clause B, terminates automatically upon any assertion by lessee or successor of jurisdiction, adverse interest, or claim of ownership over the lensor's adjoining parcels. Clause C, non-transferable, does not run with the land, revocable at will upon 30 days written notice to lessee, or any successor governing entity. Eleanor had been precise. The license was permission, not property. Conditional time limited with a self-destruct clause inside it that Diane had triggered on Friday night in front of 30 witnesses on my phone recording. She had done it herself. I had not laid a finger on her. I called Ramon Saturday night and read him the 3 clauses, the 5 statements, and the spreadsheet. He listened without interrupting. Don't move on the road yet, he said. Don't send the revocation. Wait for her to file Monday. Get the file stamped copy from the courthouse Tuesday, then mail. That's what I was going to do. Good. You're going to want a lawyer in your corner before Thursday, not for the road, for the room. Calderon. Call her Sunday. I hung up. Then I drafted the document I had been writing in my head since Friday night. A 30-day formal notice of revocation of the 1978 license addressed to the Lakeside, Pines HOA Board, and to every individual homeowner in the subdivision by name and lot number. Rayon edited it by phone Sunday afternoon line by line. Calderon on a 15-minute call Sunday evening signed off on the language. Monday morning, I drove to the county recorder's office and pulled the public record list of all 96 homeowners in Lakeside Pines. I went home, printed 96 envelopes, 96 cover letters, and 96 Clause B highlighted copies of the license. I sealed them. I put them in the bottom drawer of my desk. I did not mail them yet. Monday afternoon, Diane filed the lien. He lit her. By Monday evening, every cabin had a fresh orange sticker on the porch. I let those stay too. Wednesday, she filed a second lien, citing continued noncompliance. I let that one stay, also. Every signature she put on a public document was a brick in the wall I was about to drop on her. The wall was getting tall. The Thursday before Memorial Day weekend, Maria called me at 10:47 in the morning. She was crying. Mr. Reyes, There are men at the cabins. They are changing the locks. The man with the clipboard told me to leave. I was on the highway 20 minutes out. I had been at the hardware store buying flagpole hardware for cabin 9. I told her to stay in her car, lock the doors, and not get out for anyone. I drove back at the legal limit. I did not speed. I needed everything that happened in the next 2 hours to be on my side of every line. I pulled up to the PR. Operation at 11:22. Diane's Cadillac was gone. So was the contractor's truck. So was Greg. What was left was 4 cabins, 3, 7, 11, 14, with brand new brass deadbolts in their front doors, the old lock cylinders lying in the dirt of each porch, and a printed yellow sheet stapled to each door. HOA lockout notice compliance pending. Property under Lakeside Pines. HOA management until further notice. Entry, unauthorized. Maria's hatchback was still in the gravel turnaround, engine off, doors locked. I waved through the windshield. She got out shaking. They came at 9. She said a man with a clipboard, a man in a navy blazer, and a contractor with a drill. They photographed everything. The man with the clipboard kept smiling. I told her to sit on the porch of cabin 1 and drink some water. Then I walked the line of the 4 cabins and looked at each new lock. I did not touch them. I went back to the office and pulled the security cam footage from the eaves of all 4 cabins. I had installed those cameras 3 years ago after a break-in down the road. 4 wide-angle units, HD timestamped, recording to a local drive and an independent cloud. I had never advertised them. The footage was clean. 0:14 a.m. Diane's Cadillac and a white contractor van arrive. Diane in navy blazer, Greg with the clipboard and the printed yellow sheets. A third man, mid-50s, work shirt, drill case in hand. He approaches cabin 3 first. 9:17 a.m. The contractor drills out the original lock. Greg photographs the empty hole. Diane stands 6 feet away, arms crossed, watching, and smiles. The footage caught it from a high angle, perfectly clear. The smile of a woman watching something she had been planning for weeks. The same sequence repeated at cabins 7, 11, and 14. By 10:38, the 3 of them got into their vehicles and drove away. I downloaded the footage and backed it up to the office laptop into a second cloud account Ramon had told me to open that morning. 3 copies. I did not post anything online. Then I called the county sheriff's department non-emergency line. I did not ask for an arrest. I asked for a deputy to come out and file a report. I told the dispatcher I was the recorded property owner and that a third party had changed the locks on 4 of my structures without a court order. She said someone would be out within the hour. I sat down on the porch of cabin 1 with Maria and waited. The deputy arrived at 12:18. Young, maybe 28. Name tag Reina, no relation. Body camera clipped to his vest. I had laid out on the dining table the recorded 1978 deed, the surveyor's plat, the certificates of occupancy for all 15 cabins, my driver's license, the current property tax receipt, and a single printed still image from the cam. Diane smiling, watching the contractor drill out cabin 3's lock. He looked at the deed. He looked at the photo. He turned his body camera on. Mr. Reyes, I'm recording. Can you confirm on the record that you are the owner of these properties and that the locks on these 4 cabins were changed today without your authorization? I am Carlos Ras. I am the owner through Ras Holdings LLC of the parcel and all 15 structures shown on this plat. 4 of those structures had their locks changed today between 9:14 and 10:38 this morning without my authorization by Sal, a contractor hired by the Lakeside Pines Homeowners Association at the direction of Board President Diane Haverson. He nodded. Sir, do you want to press charges for criminal trespass and tampering? Not today. I want a report. I want a case number. I want it on paper that I am the owner, that this happened, and that you were here. If she or her contractor returned without a court order, then yes, today I want the record. That's the smart play, sir. He filed the report from my dining table. Case number assigned at 12:53. He photographed each cabin door and each cut lock cylinder with his body cam. Then he asked me for Diane's number. I gave it to him. He stepped onto the porch and called her. I could hear his side of the conversation through the screen door. Ma'am, this is Deputy Reina with the County Sheriff's Department. I am at the Reyes property. I am standing in front of 4 structures that had their locks changed this morning by a contractor and your employee. Mr. Reyes is the recorded owner. Mom, listen to me. If you your contractor, or any agent of the Lakeside Pines, HOA, returns to this property without a court order, you will be arrested for criminal trespass and tampering with private property. Are we clear? Appa. Are we clear, ma'am? A shorter pause. Thank you. Have a good day. He came back inside, gave me a copy of the report, and cut the 4 new dead bolts off the cabin doors with bolt cutters from his trunk. He left the cut locks on the porches. For your face. I'll, he said. He drove off at 1:34. The renters arrived at 4. 3 families, all repeat customers. I met them in the gravel turnaround and refunded half of each stay on the spot. I told them plainly that there had been an HOA situation that morning, that it was resolved, that I would not let it touch their weekend. Maria and I, and Hank, who had driven over without being asked, cleaned all 4 cabins by 5:30. The man from the 3rd family, a couple from Charlotte, stood with me on the porch of cabin 7 after his kids ran down to the dock. Anything we should know for next time? It will be over by next month. He looked at me for a moment. Yes, sir, he said. It will be. That night, after the renters were settled and Maria had gone home, I sat at my desk and opened the bottom drawer. The 96 envelopes were still there, sealed, addressed, ready. I added 1 page to each, a copy of Deputy Reyna's report, case number visible at the top. I added 1 more, a single still image printed on regular paper of Diane Haverson standing in the driveway of cabin 3 at 9:17 in the morning, arms crossed, watching the contractor drill out my lock, smiling. I received each envelope. She had asked me on Friday whether I'd ever read the road document. I had. Tomorrow she would too. So would all 96 of her neighbors. At the same time, 2 weeks passed. Diane went silent for the first 3 days. Then she came back louder. The Tuesday after Memorial Day, she walked into the county clerk's office at 9 in the morning and filed a formal notice of lien and claim of jurisdiction against my property. It was on Lakeside Pines' HOA letterhead. It listed every one of my 15 cabin addresses by lot number. It claimed HOA authority over each. It demanded the court schedule a forced compliance hearing. It was her second written assertion of jurisdiction. The first had been Friday night at the podium on my phone recording. This one was on county paper in the public record signed by her in blue ink. File stamped at 9:14 a.m. She picked the time on purpose. She did not know the time was already mine. Rayon called me from his office Tuesday afternoon. She filed. I know. I have the file stamped copy. Carlos, you've got her twice. You can mail today. I know. I'm waiting until Wednesday. Why? Because the hearing is Thursday. If they get the envelopes Tuesday, she might catch wind in time to amend her file. If they get them Wednesday afternoon, she's in compliance prep with her lawyer all day Wednesday, and she won't check her own mailbox until after work. By then, it's too late. There was a pause on the line. Then he laughed quietly, the way our father used to laugh. Dad would have done it on Wednesday too. I know. The local newspaper picked the story up Wednesday morning. B section. Page 3. HOA versus Lakeside cabin owner. $87,000 dispute heads to court. The reporter quoted Diane. She called the cabins illegal short-term rentals operating outside community standards. She called me non-compliant. She did not anywhere in 2 columns of print mention the word easement or license, or the surname of the man who had laid the asphalt under her tires. She did not because she did not know there was anything to mention. I read the article standing at the kitchen counter with my second cup of coffee. Then I folded the paper and set it on the metal box on my desk. I did not respond publicly. I did not call the reporter. I did not post anything on the Lakeside Pines neighborhood Facebook page. What I did instead on Tuesday evening was call Miss Calderon and ask her to come to the cabins. Adriana Calderon had practiced land rights law in this county for 31 years. She had once told me she'd become a lawyer because her grandfather lost a farm to a courthouse mistake nobody bothered to fix. She arrived Tuesday at 6 in the evening with a manila folder and a thermos of tea. I laid everything on the dining table: the 1978 deed, the plat, the license document with all 3 clauses highlighted, the phone recording from Friday transcribed and time-coded, Deputy Reyna's report, the cam footage of Diane smiling, the 5 witness statements from Sarah's kitchen, Mike's spreadsheet bagged separately, the newspaper article folded. Calderon read for 46 minutes without speaking. When she finished, she took her reading glasses off and set them on top of the license. Carlos, I have done this work for 31 years. I have never seen a case this clean. How clean? Clean enough that I am going to file a 3-line response to her petition tomorrow morning. Property ownership and access rights to be addressed at hearing. Counter-filing forthcoming. That is all I am going to give her lawyer to read between now and Thursday at 2 p.m. What about the corruption material? She looked at the th. Drive that goes to the Attorney General after Thursday, not a minute before. If I introduce it now, the press eats the road story alive, and the road story is what her board will try to settle out of court the second they hear the word fraud. I want her in that courtroom Thursday with no off-ramp. I want her to argue the lien. I want her to keep arguing it. And then I want you to put the license on the bench in front of Judge Tanaka and watch her lawyer's face change. I looked at her. You want her to walk in confident. I want her to walk in believing she is going to win. That's what makes the next 20 minutes work. I nodded. She wrote the 3-line response on a yellow pad in 12 seconds. She filed it electronically at 9:04 the next morning. Wednesday afternoon, I drove to the post office in town with a cardboard banker's box on the passenger seat. 96 envelopes. Each one contained in order a 1-page cover letter signed by me, addressed to the homeowner by name and lot number. A formal notice of revocation of the 1978 road license, effective 30 days from receipt. A full copy of the recorded license document with Clause B highlighted in yellow marker. A copy of Diane's notice of lien. Knee and claim of jurisdiction filed Tuesday at the county clerk's office. That is the trigger event for Clause B. Deputy Reyna's Memorial Day report, and one printed still image of Diane Haverson standing in the driveway of cabin 3, arms crossed, watching the contractor drill out my lock, smiling. I did not include a copy for Diane. She was a homeowner in Lakeside Pines. She would receive her envelope from the postman like everyone else. I mailed all 96 registered return receipt requested. Doris at the counter 22 years at that post office knew my father looked at the stack. Carlos, that's a lot of certified mail. It is. Good news or bad news. Depends on which side of the road they live on. She didn't ask anything else. She gave me 96 green return receipt cards in a rubber band and charged me $48,612. I drove home with the cards on the passenger seat. That evening, Diane posted on the Lakeside Pines neighborhood Facebook page. Sarah screenshotted it and sent it to me at 8:47 p.m. See you all in court tomorrow. We've got this. By Friday morning, the cabin issue will be behind us and Lakeside Pines will be a stronger community for it. Diane, it had 11 likes. It had no comments yet because, see, the envelopes had not arrived. I sat at the desk and looked at the post for a long time. Diane had spent the day in compliance hearing prep, going over the lien, going over the covenant amendments, going over contiguous lakefront parcels. She had not opened her mailbox. Tomorrow morning she would drive out of her garage on her way to court, and she would not stop at the mailbox on her way out either, because she would be running late, the way confident people often are. I closed the laptop. The 1978 license sat on my desk under the lamp, 12 pages, faded notary stamp, my father's signature and fountain pen at the bottom of page 12. I slept fine that night. By 9 a.m. tomorrow, 96 garage doors would open onto a problem none of them had asked for. By 2 p.m., the woman who built that problem would be sitting across from me in court, still thinking she was the one with leverage. The first envelope was opened at 9:04 in the morning by a retired school teacher on Cedar Court named Helen Brisby. She read the cover letter, the highlighted Clause B, and Diane's lien filing in that order, sat down on her front step, and called her son in Atlanta to ask him what revocable license means. And whether on June 27th she would no longer have a legal way to drive home. By 9:30, her son had explained it. By 9:45, Helen had called 4 neighbors. By 10 o'clock, the Lakeside Pines neighborhood Facebook page had 47 new posts and 200 comments. By 10:30, Sarah's phone was ringing every 90 seconds. By 11 o'clock, there were 14 cars in my driveway. I was not there. I had left the house at 8 o'clock, driven into town, parked behind the courthouse, and met Calderon in the small conference room across from courtroom 4B. She drank the rest of her thermos. Carlos, say nothing during the opening 20 minutes. Let her lawyer present the lien. When the judge addresses you, you say what we drafted and do not look at her. Yes. She walked me down the corridor. Diane was already inside, sitting at the plaintiff's table in a navy blazer and pearls. The same outfit she had worn the morning she came up my road in the Cadillac. She had her clipboard. She had her contract attorney, a man in his 50s with a yellow tie. She did not see me come in. I sat down at the defendant's table behind Calderon. The hearing was called to order at 21 p.m. by Judge Robert Tanaka, who had been on the bench 18 years and had a FAQ. That did not register surprise easily. Diane's lawyer presented the lien as an opening statement. 8 minutes. He hit every note. He was professional and confident, and I could see in his shoulders he had not read past the lien filing in his own brief. When he sat down, Diane glanced at him with a small approving nod. Calderon stood up. Your Honor, before we address the merits of the lien, we'd like to introduce 3 documents that resolve the matter of jurisdiction. She walked to the bench. The first is the recorded 1978 deed and certified plat establishing that the parcel containing all 15 cabin, structures and the half-mile of access road serving the Lakeside Pines subdivision is owned by Rays Holdings LLC, recorded the 14th of June 1978. She placed the second document. The second is a recorded revocable license for ingress and egress executed the same day between Rays Holdings LLC and the Lakeside Pines developer of record. This license, not an easement, is what authorizes Lakeside Pines residents to use the access road. We have highlighted Clause B, which states that the license terminates automatically upon any assertion by the lessee or any successor governing entity of jurisdiction, action or claim of ownership over the licensor's adjoining parcels. She placed the third document. The third is the formal notice of revocation of that license mailed yesterday afternoon to the Lakeside Pines HOA board and to all 96 homeowners in the subdivision, citing as the trigger event Ms. Haverson's notice of lien and claim of jurisdiction filed in this courthouse Tuesday morning at 9:14 a.m. She stepped back. The license began revoking yesterday at 5 p.m. 30-day notice runs out on the 27th of next month. After that date, no resident of Lakeside Pines has any legal authority to drive on the road that connects their homes to the highway. The courtroom did not gasp. What happened was a slow, muscular stillness. 30 bodies going quiet at once. The way a forest goes quiet before a deer steps out. Judge Tanaka read each document in order. He set them down. He looked at Diane's lawyer. The lawyer leaned over and whispered something to Diane. Diane's smile fell off. The eyes went first, then the mouth. I had told Calderon I would not look at her, but at that moment, I looked because the moment was mine, and I had paid for it with 8 years of leaving a metal box closed. That's not, Diane said, half standing. That's a private road. We have rights to use it, Miss Haverson. That road has been used by residents for 30 years, Your Honor. Miss Haverson, sit down. She sat down. Calderon, dry as a desert, you had a license to use it. As of yesterday afternoon, that license is in formal revocation. In approximately 28 days, none of your members will have legal access to their homes via that road unless they come to terms with my client. Diane's lawyer turned and looked at her with the look lawyers reserve for clients who have not told them the whole story. Your Honor, may we have a brief recess? 10 minutes. He took Diane by the elbow and walked her out. Through the door, we could hear his voice low and angry, and Diane's higher on the verge of something. Half the gallery had pulled out their phones during the recess. Several were Lakeside Pines' residents. One was Helen Brisbane, who had come with her son. She read her phone, looked up at the courtroom door, and walked over to the wall to call Diane's husband. When the recess ended at 2:21, the lawyer came back alone, then turned and gestured for Diane to follow. She walked back to the plaintiff's table the way a woman walks toward a stove she has just been told is hot. Your Honor, the lawyer's voice was carefully drained. On behalf of the Lakeside Pines Homeowners Association, we hereby withdraw the notice of lien and claim of jurisdiction filed Tuesday. We withdraw the assertion of HOA authority over the Rays Holdings LLC parcel. We withdraw any characterization of the access road as community property. Judge Tanaka wrote without looking up. Granted, so entered. He turned to me. Mr. Rays, what is your position? I stood up. Your Honor, the license remains revoked. The Lakeside Pines' HOA claimed land that was never theirs. I'd like the court to formally acknowledge that the parcel, the cabins, and the access road are mine, and to strike Miss Haverson's lien filing from the county record. Mr. Rays, do you intend to negotiate access for the Lakeside Pines homeowners during the 30-day notice period? Yes, Your Honor. With a properly elected board? Not with this one. Calderon, beside me, did not smile, but the corner of her mouth moved. She submitted the supporting receipts in fast sequence. The phone recording from the May 30th HOA meeting with Diane's 3 voluntary on-record admissions, transcribed and time-coded. Deputy Reyna's Memorial Day report. The cam footage of Diane watching the contractor drill the locks on cabin 3. The 5 witness statements, and only at the end, briefly, Mike Delgado's archived HOA financial summary, which she requested be referred to the State Attorney General for review of the Board Discretionary Fund, and the Haverson Strategy Group consulting contract. Judge Tanaka took 12 seconds to read each. He looked up. Leanne struck from the county record. Jurisdictional claim dismissed with prejudice. License revocation upheld pending the 30-day notice period. Financial records referred to the State Attorney General. Court is adjourned. The gavel came down at 2:38 p.m. Diane sat motionless. Greg, who had been in the gallery, was already gone. He had left during the recess. The reporter from the local paper was on the courthouse steps. Miss Haverson, any comment? She walked past him without speaking. I came out behind her. No faster, no slower. The reporter turned to me. I gave him one sentence. The road has been mine since 1978. It always was. I got in my truck and drove home. When I turned off the highway and onto my own pavement, I felt the sea. Under my tires the way I had felt it Friday night 2 weeks earlier. I felt it differently again. The road was mine. It always was. The lien was struck from the county record on Friday morning, the day after the hearing. The clerk who processed it was a woman in her 50s named Lillian, who had been my father's friend in the 80s. She handed me the file's stamped copy across the counter without a word. That nod was the only conversation we had about it. The jurisdictional claim was dismissed with prejudice the same afternoon. Diane could not refile ever. The Attorney General's office sent its first letter 11 days later to the HOA, to Diane, and to Daniel Haverson at his home address in the next county. Subpoenas followed for the board discretionary fund records and every Haverson Strategy Group invoice going back 4 years. Diane resigned from the board on a Tuesday morning, citing personal reasons. 3 other members resigned within the week. Greg was one, Lorraine was another. The Haverson Strategy Group refunded $11,000 before the AG could decide whether to prosecute. Daniel kept his license but lost his only client. The HOA's total exposure ran to roughly $180,000. The remaining G-Board passed a special assessment to cover it about $1,900 per household, across 96 homes. They were furious. They were not furious at me. The Coopers filed a civil suit in July to recover their $9,400 in TARP fines. The Patels filed in August. Both won quietly within 6 weeks. Bill Cooper called me the day his check cleared and said his wife had cried at the kitchen table she had not cried in 2023 when they sold the boat. Ainley Patel sent me a card. On day 28 of the 30-day revocation period, I sat down at Sarah's kitchen table again. The same table, the same coffee. The room was different. There were 3 people across from me. Sarah, newly elected board president by 91-0 with 5 abstentions. Hank, treasurer because he was the only person on the lake who had never been afraid to say no to Diane, and a public school principal named Beatrick Okafor, elected secretary on the strength of a single sentence at the candidate meeting. I will read every page of every document this board signs. Calderon was beside me with the new draft. We negotiated for 90 minutes. I extended the courtesy I had not extended to the developer in 1995. I gave them a real recorded easement this time, not auto license. An easement runs with the land. Future homeowners would not have to renegotiate every time a new board got ambitious. The fee was $12 per home per year, the same dollar my father had charged Holloway in 1978, indexed for 47 years of inflation. There was a single termination clause drafted in plain English. This easement shall terminate automatically and without further notice if any future Lakeside Pines HOA board officer or governing entity asserts jurisdiction claim of ownership or adverse interest over any portion of the licensor's adjoining lakefront parcels or improvements thereon. Sarah read it once and signed it. Hank read it twice and signed it. Beatrice read every page of every attached schedule, made one correction to a footnote and signed it. The 96 homeowners ratified the agreement 2 weeks later, 94-2. Diane and her husband had moved out of state by then. Their corner lot house went up for sale on a Thursday and was under contract by Sunday. The new owners, a young couple from Raleigh, drove up my road for the first time on a Saturday afternoon and waved as they passed the cabins. The cabins reopened the second weekend in June, the 3 Memorial Day. Families I had refunded came back in July, free weekend on me. The man from Charlotte stood with me on the porch of cabin 7 again while his kids ran down to the dock. You said it would be over by next month. It is. Yes, sir, he said. It is. Maria got a raise that summer, $2 an hour. She tried to refuse it. I told her I had been underpaying her for 3 years, and the raise was overdue. She accepted on the second offer. The local paper ran a follow-up the 3rd week of July. The phrase tried to claim 15 cabins they didn't own appeared in the 2nd paragraph. Diane's name appeared in the 4th. Hank brought me a 6-pack the day the AG report was released. We sat on the dock at cabin 1 and drank 2 bottles each. He told me a story I had not heard before about a Saturday in 1986 when Manuel Reyes had delivered a check to a contractor whose son had died 2 months before the work was even finished because the contractor needed the money. I had not known about the check. Hank had been there. He did not tell me to make me feel something. He told me because it was true. The day the AG report was released was also the day I went back to cabin 3. The orange code violation sticker was STI, all on the porch post. It had been there for 11 weeks. Through Memorial Day, through the lockout, through the hearing, through the resignations, through the lien being struck, through the easement being signed, through every weekend of paying renters who had walked past it and not said anything because they were on vacation, and a sticker on a porch post was not their business. I had left it there on purpose. I had told myself the morning Diane drove up my flower bed that I would peel it the day I knew the story was over. I peeled it now. It came off in one piece. The adhesive had baked in for almost 3 months and pulled the top layer of porch paint with it. There was a small ghost of yellow left behind, sticky to the touch. I would sand it down and repaint the post on Sunday. I held the stick.